This educational program is intended for the personal, non-commercial use of its listener and may not be reproduced for any commercial purpose without the written permission of Rex Crandell and CALDA. The policies, positions, views and opinions expressed and or provided herein are not those of the State Bar of California, CALDA or any entity associated therewith, and are strictly those of the authors or speakers. No representations or guarantees of any kind are made with respect to the accuracy of the written, visual, oral or audio portions of this presentation, and nothing herein should be relied upon to answer any legal questions. The written, oral or visual information expressed or provided herein should not be relied upon in dealing with any specific legal matter. No attorney-client or CPA-client relationship is created by any part of this educational program and related activities. Attorneys, CPAs or LDAs using the information expressed and provided herein in dealing with a specific client or clients, and their own legal matters should also research original sources of authority.
Okay, great. Hello, everyone. Welcome. We are going to be discussing trust, part one, the revocable trust in estate planning. Rex Crandell is presenting. Rex has many years of experience in bookkeeping, accounting, financial statement preparation, audits, reviews, and consulting. He has prepared thousands of income tax returns from simple to the most complex, including individuals, businesses, small and large, partnerships, S and C corporations, limited liability companies, estates, trusts, nonprofits, homeowner associations, and sales tax and payroll reports. So this is part one of the whole series. Thank you guys very much for joining and getting this very awesome opportunity with Mr. Randall. I will ask everyone, please make sure you go ahead. If you have any questions throughout the presentation, go ahead and type them in the Q&A. And whenever there is an opportunity to break in the presentation, we'll go ahead and address those questions. Okay. Enjoy.
Okay. Well, I'm happy to be here. I'm eagerly awaiting the opportunity to explain all the information that we have tonight about trust. This is the first of a two-part class, and the next class will be part two, and we'll continue on. And we are going to be covering quite a bit of information, and you just need to follow along. I'll give you examples of what the situation is. We have someone has a microphone on, perhaps. Okay, so we're going to cover a lot of information. We're going to go from soup to nuts, from the beginning through a lot of details, and not only that, the facts and the foundational, but also a lot of the strategies and thought process that goes into estate planning. And we can handle a few questions during the presentation. If it starts running behind, we might need to move all the questions to the end if we're going to cover the material, because there is quite a bit of material. So the learning objectives are defining trusts, explaining how they work and how they impact families. We're going to get into the vocabulary and things to consider when you're creating a revocable trust. So we start off with, does everyone need a revocable trust? Well, the answer is no. There are a lot of people who don't need a revocable trust. And usually they're people who have modest estates. persons who have no real estate. And so if, in California, every state is different. A lot of states, everything is done by a will. But in California, because of the probate, trusts are very popular. And especially anyone who owns real property. If you have minor children, we'll get into the reasons you should probably have a trust. You want to avoid probate, the cost and delays, and you would like to have somebody take over your financial affairs immediately. Rather than on a will, for example, it might take 3 or 4 months to get an executor appointed. You do not need a trust if you have a modest estate and no real property and no complicated assets like copyrights, patents, things like that. If the value of all your property is worth, has a fair market value of less than $184,500, then there's an alternate procedure, which we'll talk about, it's an affidavit procedure where you do not need a probate and the assets should be turned over. And another situation when you don't need a revocable trust, if you have all of your assets held in a pay on death account, because that's a contract between the vendor and yourself when you created that account. Okay. What is a revocable trust? First off, simply put, it's a document. It's not necessarily a contract. It doesn't meet the definition, but there's a lot of reliance on it, and very similar to a contract. The idea of the trust is you put your wishes, how you want your assets distributed after you're gone, because you want to have a say in it, and you can make the document as simple or as complex as you want. I suggest not getting too complicated or keeping the trust going too long after your death, because it creates a burden for the successor trustees. When we create a trust, the first person that is involved here is the settlor, the person creating the trust, and that's settlor. It's not like the people coming across the United States in covered wagons. Those were settlers. A little bit different. And a revocable trust names successor trustees to take over when you no longer can manage those assets. And in married situations, we usually name each spouse as the successor trustee. Then we add 3 additional alternates to make sure we never run out of successor trustees to manage. We've had cases where the trust did not name enough alternates, and we had to go to court to have a judge appoint an alternate trustee. So you identify your distribution plan, who are your beneficiaries, and the trustee then takes care of paying the debts and distributing the assets. It does take a while. So it's a document you prepare when you're alive and distributes all your property after your death. The revocable trust, you create it and you're the initial trustee. There is some problems if you create a trust and you have alternate trustees instead of the creator, because the IRS then wants some additional reporting, where normally a revocable trust is ignored by the IRS. In terms of managing your assets, when you have assets in the trust, you are the same manager you always were. You continue to do that. You end up titling the assets in the name of your trust, and that's very important. And in California, the way that it has to be titled is in your name and as trustee of your trust. In California, you could not just name the trust as the owner of the asset. It's just a technicality. And the Successor trustee takes over when you become mentally incapacitated and works with all your vendors. And the mental incapacity could be determined by doctors, or you can name another trusted person who's not a doctor to determine incapacity. There have been some problems and delays. Doctors are sometimes reticent about issuing incapacity letters. You identify all your beneficiaries, alternate beneficiaries, contingent beneficiaries, however you want your plan to work out. And because it's revocable, you can change it at any time, revoke it. You have to do it with a certain amount of formalities, though. And one thing you want to avoid is never cross out things in your trust or line them out and initial or add things. That's called interlineation. And it's frowned on by the courts and more than likely going to be ignored. So you have to follow the formalities if you change the terms of your trust. Ordinarily, there's no court intervention when a person dies with a trust, but the court is always there if needed. There's a problem with a trustee or with an asset or with a vendor. The court is always available to the trust and the trustee. Revocable trust and income tax. There are trusts that create separate legal entities for tax purposes. A revocable trust is not. Sometimes it's called a grantor trust, which means all of the income flows through to the grantor. You'll not file a separate tax return. You'll still get 1099s in your Social Security number. And if you're trying to fund a trust and the vendor says that we have to get a separate ID number, don't do it because it causes problems. You should only be using your Social Security numbers in dealing with vendors on your revocable trust. And as far as IRS and the State Franchise Tax Board, a revocable trust before you die is a non-entity or non-existent. Okay, revocable trust and estate taxes, it's also called estate and inheritance tax. There's, oops, oh man. I have a technical problem here. The darn Windows took over to try to update my computer. Well, looks like I recovered. Panic attack. So thank you, Microsoft, for coming in at our rescue. So estate and inheritance tax. It doesn't apply very much. It's kind of a waste of time to talk about for most people, not all. There's only about 1% of the population who will pay estate tax. And it's not income, it's based on property being transferred, and the government wants to tax anything for an individual if you have over 12,060,000 of fair market value of assets, or if it's a married couple above 24,120,000. So for the vast majority, 99+% of the population, you don't have to worry about estate tax. But don't get confused in that because you have a trust and you avoid probate, it has no impact on the estate and inheritance tax. That's a common misconception. When you have minor children, there's a problem with children in California owning assets. A child cannot have a bequest of more than $5,000. State says they cannot own it unless there's a guardian or you keep it in trust for the child until they turn 18. And you don't nominate a guardian. A guardian is a court-appointed person to help to raise your child. You nominate a guardian only in a will. And I say nominate because it's the judge who decides who is going to be the guardian of your minor children. And it's not automatic, as you might think. Another way to avoid this $5,000 rule, it's kind of a workaround, is using a custodian account. And where you have like a Charles Schwab account as a custodian, Uniform Gift to Minors Act type of account. But it's not used that frequently for estate planning. For couples, we generally prepare one revocable living trust for each. For one couple, we do one trust. And each of the spouses' assets go into that. If you put property into trust, which is separate property, when it comes back out, it's still separate property. Same thing with community property. And if you have unmarried couples that want to do estate planning together, you can still do that in a one trust plan. One thing that's suggested is to clearly identify the separate assets of each partner that goes in, and also have a property agreement in addition to the trust, that this commingled property doesn't become somewhat like quasi-community property. Each spouse can have different distribution plans, which happens in blended families where there's children from a previous marriage. There's no rule that says spouses cannot have separate trusts, but you just don't see it very often. And when you have a trust that describes other trusts within the text, you can create sub-trusts out of the one trust. And oftentimes that's done on the death of one spouse. And people are surprised that you have one trust and then later on there's four, like if you had one for each child, for example. What happens to your debts with a revocable trust? Well, you get to pay your debts. You don't get to get out of the paying the debts. And creditors still look to you for repayment of the debts. And I frequently get the question of, I have a mortgage on my house and I'm going to put it in the trust. Is the lender going to call the loan and say it's all due right now because they see it as a separate owner? And the answer is no. Based on federal law, the Garn-St. Germain Act, the lender cannot accelerate a loan when you put your house in a revocable trust. There are certain types of irrevocable trusts that are protection from creditors in certain circumstances. After your death, the trust is no longer, normally not revocable. The successor trustee pays your liabilities, then distributes your assets to your beneficiary according to the text of your trust. And I say that revocable trusts become irrevocable on death. That's not a requirement of the law, it's custom. I have drafted trusts where the language said that the trust could be amended after death in certain circumstances. What do you need to decide when you're making a trust? Well, you need to kind of come up with your overall plan. What I recommend people do is list in an organized format, one spreadsheet or group of papers, all your assets, real property, banks, and list the things that are going to be transferred on your passing. That helps you in identifying things on how you want to handle those in your estate plan. Normally, you want to have your real property in your trust to avoid probate, banks, and investment accounts should be in your trust. And what I say in, it means titling. Titling means ownership. One way that we check financial accounts when we do tax, we get the statements in from the vendor, let's say Merrill Lynch, and we look at the mailing label, and if it says, you know, Joe and Mary client with nothing else, I'm suspicious that that account is not in the trust. It should have some additional letters on it, like trustee or the name of the trust. And I've caught many mistakes that way. Personal property, that's anything that's not real property, that's movable. And you want to put that in your trust. And since there's no record of title, what we do is a blanket assignment of all personal property to the trust, and it's good up to that date. We also put wording in that says anything after acquired after this document's prepared is in the trust, but there's some question whether that's enforceable. And if you ever amend your trust, you should also update your assignment of personal property each time. Normally, these assets do not go into a revocable trust. Your individual retirement account, pension, life insurance, annuities. And the reason that these assets don't get owned by the trust is that the way they're structured, when you create the account, you make an agreement with the vendor. And in that agreement, it says, on my death, I want to have my 3 kids receive my pension equally. So it's based on a beneficiary statement. It's not going to be controlled by your trust. It's not going to be controlled by your will. And when we're doing estate plans, I recommend everybody check each of your beneficiary statements or update them, because I've seen situations where there were prior relationships to a current couple, and one of the prior relationship was listed as the beneficiary in the plan, in the beneficiary statement. So you can't just assume that everything is the way it should be. You need to verify. Choosing trustees, very important choice. Couples name each other first, and one spouse dies. Surviving spouse is usually the trustee. We identify a husband and wife and then require at least 3 other trustworthy and responsible successors so we don't run out of alternate trustees ever. And you want some personal characteristics, like they're going to follow instructions, they have some stick-to-itiveness, they get along well with other people, especially the other beneficiaries. And if there's going to be a conflict between the trustee and any of the beneficiaries, you should seriously consider getting an alternate. And what people normally do is name an adult child, the most responsible, to be the trustee, but you have to weigh the possibility of conflict between the beneficiaries, and there's a lot of interfamily sibling rivalry that happens surprisingly in estate and trust administration, where 2 siblings are just at loggerheads at each other because of some antique teapot that they both don't want to give away, or they have a personal problem that you got to ride in the front seat when we were 6 years old. So they always say that psychologists are cheaper than attorneys to resolve those kind of conflicts. But the best way in your trust try not to name people who might end up being in conflict. Who do you name for your trust beneficiaries? Well, if you can't think of anybody, I want to volunteer. Just kidding. You might consider your Christmas list. Who do you normally give gifts to? That's an indication. Extended family members and friends, people that have helped you out in the past, and respected charitable organizations. If you do make a gift to a charitable organization, make it extremely specific, because we did one estate plan where they wanted to give assets to the Animal Rescue Foundation. There are hundreds and hundreds of animal rescue foundations in the United States. Which one did you mean? We did resolve that. Arranging for your debts, the trustee needs to pay off your debts and taxes before the distributions. And it takes a while to determine what the debts are. Oftentimes, a successor trustee will need to watch the mail to find out if there's bills coming that give evidence of debt. And another problem that's developing more and more are cyber and login password kind of problems. So you have somebody who's paying a debt on an automatic bill pay at their bank, and the successor trustee does not have the login and password in order to either stop the transfers or determine that there are hidden liabilities. One idea we do in that area is you might consider putting a sealed envelope in your estate plan to your successor trustee and say, only open in the event of my death, and then your passwords are in there. Determining incapacity. What is incapacity? Well, it could be like Alzheimer's, could be brain injury, could be a lot of things. People most often name a doctor or a licensed physician to make a written determination. But as we found that sometimes it takes a while and the doctors are kind of hesitant to issue them. You can legally name another person, another responsible person, to determine incapacity. And you might want to have that wording in your trust. It would be the same, usually the same person in your durable power of attorney for financial management. But you have some flexibility there. I think it's a little excessive to require 2 doctors to sign off, and then make sure that you have provisions when incapacity has been recovered. For example, there are several cases where people have had urinary tract infections, and that affects their mind during that infection where they're incapacitated. And then they get over the illness, and then they're lucid and normal. So it is a problem sometimes with the incapacity determinations. Creating a valid living trust, a revocable trust. The term living trust comes about originally because the trust was made by living people. And another type of trust is called a testamentary trust. So it's in your will and it doesn't get created till after you die. So you identify who's making the trust, and you're describing your intent to create a trust. Describe who you want to manage, the assets, where they go. Describe any conditions or actions you want to take place. Frequently we'll see for minor children, they want to take 1/3 at 25, a distribution, 1/3 of the assets, 1/3 at 30, and another 1/3 at 35. So that if an irresponsible beneficiary burns through the first $2 million of inheritance in 30 days. When they're 25, maybe they wise up by the time they're 30 and act more responsibly. It is a good idea to create a list of separate property in a trust just to identify it, so it's not assumed that everything is community property between married couples. And signing in front of a notary public. Now, that is done customarily. It's not required, but I would not recommend doing it any other way. Like you do on a will, you have two witnesses, but just keep it simple and have a notarized trust document. Okay, naming your trust. I see a lot of trusts that have first, middle, last name husband, first, middle, last name wife, and then the date it was created. And the problem with all that wording and alpha description is that it just creates a little bit of an administrative burden for your successor trustees, that they got to write out all that name stuff. And in the future, there's no requirement that you name your trust in your name. People do it all the time. They feel better doing that. Not required. We create many trusts in other names rather than the individual names. So we had a client that was into rock collecting and crystals. They had a crystal trust. We had another client who, laughingly, they had one daughter and they wanted to name the daughter's name as her retirement trust as the name of their trust. So when she sees it, all this money coming in from her parents is her retirement. So, and another, it's not for anonymity, it's not foolproof, but if you have property listed in the name of a trust, like that's not your name, and let's say we call it the Evergreen Trust, and somebody's looking at the public record to see who owns that property, there's a little bit of anonymity there that your name doesn't show up as the owner, and the Evergreen Trust shows up. But it does not stop sophisticated researchers from getting the data. Transferring assets to the name of your trust. We do it with deeds, transfer deeds on real property. We won't let a trust go out of our office unless we do the deeds and have it recorded. A lot of vendors, banks, and investment companies have their own trust transfer forms. You could look on their website. It might be easier to fill out their form and have them accept it rather than you send them a letter and they reject it and say that you need to redo it in another format. But transferring property to your trust is just so very vital for estate planning. If it's not controlled by your trust, correction, if it's not named in your trust, it cannot be managed by the trustee. The example or comparison is a president of a corporation can manage the assets that are titled in the name of the corporation. If the title is in some other person's name, the president of that corporation can't do anything with it. So, and normally when you have a trust and you have a will, we create a pour over will that says, whatever you want to know about my assets, go put it in the trust or do what the trust says. Certification of trust. This is a summary of the terms of the trust, and its purpose is to leave out important or personal items you don't want disclosed, like distribution plans or restrictions on distributions to a child that has chemical dependency, or a lot of different things that could be there. And the certification of trust describes and assures any person who receives it that the trust exists, it's not been revoked, is still in force and effect. The only trouble is, even though they're good documents, sometimes the banks and the investment companies won't take them. They'll say, give me the original trust. And then you have a choice of either not using that vendor or giving them a copy of the trust. And normally it's not a problem with a bank or brokerage house. They just scan in the documents, and it's not like they publish it on the internet. That you may have certain purposes in your trust that you would rather not disclose. And that's another reason for using a certification of trust. Keeping your trust up to date. There's several things. I suggest that clients update their trust every 5 years, because there's law changes. For example, the no contest clause now, you have trusts that were created before 2017, and they have the old no contest clause for California, and it creates some problems because California changed it. If you move to another state, it's a good idea to have your estate plan reviewed in that state. On the alternate view of that, if you have a trust or an estate plan in California and you own property in another state, you want to make sure you title that property in the name of your trust, so you don't have a probate in another state and a trust here. Adding property to your trust. When you buy a new house, you should make sure the deed gets recorded that says that you're holding title in the name of your trust. Sometimes you have to work with a bank because they'll want to record the deed in your name only at first, and then you have to transfer back in your trust after the bank's already done with the loan transaction. As I mentioned, pour over will directs the executor to put assets in the trust. It usually says if the trust is invalid, just do what the trust says. And out of custom, it's frequent that there'll be a Schedule A of assets listed in a trust. It's not required. It's just a good idea to give your successor trustees kind of a roadmap of where your assets might be, what the account numbers are, and details. It just helps put together your assets. And then if they're separate property, we usually do for each spouse a separate schedule for the separate property. Amending or restating your trust. When you amend a trust, you should use the same formalities that you did when you created the trust. For example, having the document notarized, both spouses signing it. And when you do that, we always refer back to the original trust, that clause that says it's amendable. And the other problem we get into on amended trusts, we've gotten them in where people have done a trust a long time ago and they might have 6 or 7 amendments, and they come in and they want another amendment. We won't do it. We take the whole document, wrap it all together, and do a amended and restated trust that has all new provisions in it. And that way, the successor trustee does not have this burden of going through all these changes. And when you amend a trust, you do not change the name of the trust, because you don't want to go back and prepare and record new deeds in a different trust name. You keep the trust name and the date of the original trust the same, just amend, restate all the terms and say you're revoking the prior versions. When you buy or sell assets, it does not change the term of the trust. We get clients asking, well, I sold this asset that's on my Schedule A in the trust. Do I have to amend the trust? No. If the title's held in the name of the trust, that's good enough. And another time to amend or restate your trust, life events, major life events, marriage, divorce, have a baby, or a beneficiary dies, and then maybe take a look at it every 5 years. When you refinance a house and you have the proper title in your trust, and then you decide to refinance, it seems to be a recurring problem where the banks say they're going to make you deed the property back to your name first, then they will give you the new loan. Then after the new loan is done, the property is in your name and not in your trust. So you need to remember in that circumstance to do another deed back into your trust so your house does not get require probate proceedings. If you make that kind of mistake and the trust describes the property that's supposed to be in the trust, there is a procedure called a Hegstead petition that we can ask the court to say, Your Honor, they really intended to have it in the trust. We want to have it in the trust and not do a probate. And then you get the court order that allows it to be put back in the trust. But I've noticed that not all judges will grant those Hegstead petitions. Revoking your trust. You can do that at any time, no problem. As long as you're mentally competent. If you're mentally competent, your signature means nothing. You need to follow the revocation clause. Sometimes they say it has to be revoked a certain way, otherwise it doesn't get revoked or changed. The character of property does not change when you put assets into a trust or take it out. If you have community property, it goes in a trust, it's community property. If you later take it out of the trust, and the same goes for separate property of each spouse. And either spouse can revoke a trust. You do not have to have a unanimous decision. Trust relationship between the parties. We have a trust agreement, and there's legal and equitable title is a concept in trust. The legal title is in the name of the trustee on behalf of the trust. The equitable title, who really owns this stuff, the house or whatever, is ultimately the beneficiaries. So there's a division between legal and equitable owners. And the basic players are the settlor, the person creating the trust, the trustee, and beneficiary. And I get people asking, they want a couple people to be on trustee, and I suggest against it. Having my family, my uncles had 3 people trust beneficiary trustees, and there was litigation back and forth because they couldn't agree on anything. So I would advise against having multiple trustees managing your trust property. Some types of trusts, there's many types. Inter vivos, between people, testamentary, after you die, revocable, irrevocable. Marital deduction trust has to do with estate tax, as does an exemption trust, to cut your estate in half so that the other half of the estate doesn't get inheritance tax. Special needs trusts are very important if you have children or adult children who have major disabilities or receive governmental benefits. There are split interest trust. And what that means is the income beneficiary on the trust is different from the residual beneficiary. Another type is a sprinkling trust. So you give someone authority, you have 4 kids, and you say they can give it out in percentages based on the child's need, and it doesn't have to be equal. Requirements, you have to have trust intent. It cannot be an accident. Trust must have assets. They say dry trusts are okay in most states, so that's a trust that has no assets in it. The ones that we've seen for dry trusts have been like special needs trusts, where they're a separate trust, but they're not yet funded. They're going to be funded out of the parents' revocable trust. Beneficiaries must be clearly ascertainable. Sometimes we get class gifts, all my grandkids, which is legal, but you might want to be specific. What is the trust purpose? And then the rule against perpetuities, the trust is not going to be determined valid if the trust instrument says that there's going to be distributions beyond a person who's alive now, plus 21 years after they die. That's too long in the law to have the trust operate, and it will invalidate your trust. Most trusts have a clause that limits that duration. So selection of trustees, corporate trustees, banks can be a problem. Sometimes they're cumbersome. They only want large trusts. There's licensed professional fiduciaries, which is a whole group of professionals. And the duties of a trustee are many, and they're listed in the probate code. The duty not to commingle funds, the duty to do what's best for the beneficiaries, the duty to provide information to the beneficiaries. There's quite a number of duties. And there's usually in a trust, we'll see a lot of the duties and responsibilities of the trustee enumerated and just written in the trust document. Creating a trust costs a little bit more than just making a will when you're doing documents, because generally there's a trust and a will. However, that savings up front to have a will might cost a lot more later doing a probate. And I'm not one to want to oversell trusts. There's a lot of good reasons for probate court supervision. And from our standpoint, we've seen many trusts where that so-called reliable person who was the trustee ended up embezzling a large amount of funds. And it would have been way cheaper to have done a probate than the amount of money that the trustee stole from the trust. It's a problem. Benefits, you avoid the time and delay. Probate is expensive. It does take a lot of time, and it is an unbelievable amount of paperwork the courts want. You get continual management. Right after a person dies or becomes incapacitated, the trustee can take over. Tax planning, you can divide things out to maximize tax. Another good thing about a trust is you give a roadmap of exactly what you want your trustee to do. And because there's no probate, you get faster distributions to beneficiaries. There's an element of privacy. In a will and a probate, the court file is a public record. So anyone who wants to go to the court and pull the probate file can read all the terms of your trust, and people do that. So when you have a revocable trust, you do not need to file that will with the court. So it gives you that element of privacy. There are some benefits in certain circumstances where assets can be protected because of the trust structure. A very important aspect of a trust is when seniors need to go into skilled nursing facilities, oftentimes they have housing costs that might cost $6,000 to $7,000 a month. And when they run out of cash, Medi-Cal pays for that. And the way the law is now, if you have your house in your own name and you're going to use a will, and you have received benefits from Medi-Cal, Medi-Cal can come and do a chargeback and take the value of what they gave you, which might be $900,000, back out of your house equity. You simply put the house in a trust, and Medi-Cal cannot do a chargeback and take the assets away from the beneficiary. Possible disadvantages of a trust: you need to title assets in the name of the trust. A will, you don't have to title anything. There's no court supervision. And there's a little bit more complexity. Not everybody needs a revocable trust. Trustees do sometimes illegally take assets. And when a trustee embezzles from a trust, it's ironic, but the police don't seem to give it a very high priority. They seem to get a lot of excuses on why they should do nothing, calling it a civil matter and you need to follow up with your own attorney. And it's a crime, but the police don't seem to be that concerned about it. Oh, it's a family matter. You always need to have an alternate trustee so that you don't have to go to court, and appoint a trustee. And I do point out, some people think, oh, well, if you avoid probate, you don't have any administrative costs after death. That is not true. You still have to administer and transfer assets, pay liabilities for the trust, even though you avoided probate. Special considerations: make sure you transfer real property. It needs to be in writing. We talked a little bit about Hegstead. Community property, note, okay. Joint tenancy sometimes is called a poor man's estate plan. So it's a disaster at times. Mom is getting up there a year. She puts son on the title as a joint tenant, so he's the only beneficiary. And then he has a trucking company, runs over a bunch of people, and the creditors come back and take mom's house. There's also gift tax problems in that scenario. And there's estate tax. If a beneficiary receives a house, let's say, from a decedent through a trust, and they sell the house the next day, there's no capital gains. But if you get the property before death, or you get half of it at death because of a joint tenancy, you create capital gains. Another consideration in a trust people don't think about is picking your governing jurisdiction. You can have it administered, you travel around, you want certain assets managed under the laws of New York, certain laws under the laws of Wyoming. Okay. One of the things to look out for, I think it's called the red flag, is you have someone that comes into our office and it's one of 3 children, and it just so happens that mom or dad is going to give all the assets to them, and you try to talk to mom and dad and the kid won't stop talking, and it turns out that mom or dad is not that competent, and what the child is trying to do, the adult child, is to inappropriately take bequests away from their other siblings. And that's a bad red flag. And what we do is we require the adult child to step out of the room so we can talk to mom or dad and see that they're responsive and understand what is going on. And we've had similar problems with foreign language translations, where a person doesn't speak the language that we use, and then you have someone a child who's getting a big distribution translating everything you're saying. You don't know what is being said, and it creates a bit of pause for us. Just because a trust is long doesn't mean it's good. There's title problems that come up. There are separate title holding trusts. Some people will create land trusts. It's not so common in California. If there's a change in long-term care needs, the trust might need to be updated. And we've seen many trusts where people are up in years and almost all the beneficiaries have passed and all the successor trustees have passed away. So you don't want to get that far behind. The trust agreement's a roadmap for the trustee. And you never want to have, there's a problem in California where you name a caregiver. Say mom has a trusted nurse or caregiver at home, and then they give a large amount, over $5,000, to that caregiver. The California law assumes that that's done because of undue influence, and they won't enforce the gift. So there's procedures that have to be followed if a caregiver is getting a large distribution. The purpose of a trust administration is to collect and manage assets for the decedent or the incapacitated person. Another consideration for the successor trustee is not to get sued by the beneficiaries. Beneficiaries are very frequently, they're very ungrateful for all the work that the trustee has to do. And frequently our trustee clients, you know, I've never been a trustee before, and when they get done, they say, I wish I never would have volunteered for that job. And they also have personal liability. If they do something wrong, a beneficiary can sue them and they're personally liable. One way to reduce liability for a trustee is when the trust has been fully distributed and the trustee does an accounting showing all the money transacted to the beneficiaries, is that they can bring the accounting to the court for court approval. And then when the judge signs off that the accounting's been approved, it relieves the trustee from liability for anything that was disclosed in the accounting. There are times when people will assign a trusteeship to an attorney or a CPA or other trusted person. When you're doing an administration of a trust, we always look at the public records. We found people have tens of thousands of dollars that have escheated to the state. So we are at the hour point at the present time. So we're going to stop, and I'd like to open it up for questions. Michelle, are there questions in the question room?
Yes, there are. I will go over them. So we have a question here. What is the difference between a will and a pour over will?
Okay, a will by itself has what they call dispositive provisions. It tells where the assets go. And like we saw one that was turned in for homework where they had real property in a will, appropriate, but it tells where the property goes. In a pour over will, there's the only thing it says, it's basically, it is a will, and it says, whatever you want to know, anything about where I want my things to go after my demise, go read the trust. And so the pour over will is a lot shorter than a regular will with all the details in it.
Okay. And then there is a question, what about credit card debt? Isn't the worst thing that can happen is you get bad credit, also student loans, and who cares if you're dead?
Yeah, they what happens you have personal debt, that's usually not going to be in your trust, so your estate would still be liable for that assets. But yeah, at this point, we're not talking about credit. We're talking about titling assets and leaving assets to the next generation. And we're contemplating other things than when you talk about credit, you kind of imply that you're going to get new loans on things. And when we're doing estate planning, we're not considering getting new loans.
Okay. Can you please explain in what kind of circumstances the trust becomes irrevocable after the death of the trustees?
Normally, the vast majority of revocable trusts have a clause in the trust that says this trust is revocable during the life of each spouse. And then you could say, well, after both spouses have died, the trust can no longer be amended or changed. So it's by the term of, it's written out, it's expressed and part of the terms. It's not by operation of law. And it's also not required. But most people, they don't want, they did the plan. They did their estate plan. They don't want somebody coming in and changing it. We already made up our mind.
Mm-hmm. Okay, on a trust, more specifically NOLO, Nolo asks, who will be the person that will activate the power of attorney?
Okay, that is not a trust question. That's a power of attorney question. So
Okay.
I'll defer on that.
Okay, what forms are used to amend a trust, and how do you amend one?
Okay, what you do in amending a trust is you quote back the clause in the original trust that says this trust is amendable or revocable. And you put that as the starting of your amendment. And then you go in to change everything that you want to change or add, or if you're going to amend and restate all new clauses. So basically, you're showing your authority to amend the trust, and we usually recite the exact verbatim the ability to change the trust, and then make whatever changes. It can be short, it could be long, and there's no specific form. It's free form.
Okay, and what are heirs and devise? What does heirs and devisees mean?
Okay, heirs and devisees.
Devisees.
Yeah, those are antique terms. Heirs, you got heirs at law, like when you die without a will. The rule of the table of consanguinity applies to heirs, and then devisees usually relates to someone getting real estate, but I wouldn't worry about those terms. Well, heirs, yes, heirs is used. And oftentimes in a residual clause, we've given everything else away in the trust. And there's a clause that says, if there's anything left, give it to my heirs at law.
What are the inheritance tax benefits, and what does the $15,000 inheritance tax mean?
15,000 inheritance tax, you said?
Yeah, that's what was typed.
Okay.
15,000.
Okay, those are two different concepts. There's no benefit to inheritance tax. Like most taxes, you pay and you don't get a benefit, or if you do, it's indirect. If your estate's more than $12 million as an individual, more than that, 37% is going to the government. That $15,000 number that you came up with is a different thing. It's called a gift tax. So if you give a gift of more than $15,000, then you have to file a gift tax return that could have an impact on inheritance tax.
Okay. What happens? Okay. If someone names their trust as beneficiary of their life insurance policy, is it true that the trust now becomes irrevocable and that now the trust is subject to paying capital gains tax?
No, in all regards. You can name your trust as the beneficiary on your IRA, your pension, your annuities, your life insurance. There's no prohibition against it. I advise against IRAs or pensions being given or having the beneficiary statement going to the trust, because the beneficiaries have better tax options available to them. Naming your trust on your life insurance does not create capital gains at all. And it does not make your trust irrevocable. Well, wait a minute. The undercurrent item there is you've died. Okay, so you don't get life insurance and you die. Then it goes to your trust, and now your trust is irrevocable.
Okay. When amending a trust, what if the attorney that drafted it died or is no longer in practice, and you don't have a software or format of forms for the original trust was drafted with?
Okay, I'm not sure what you're doing, but let me try. You don't need an original person that created the document. The document stands on its own, and the person that created it does not become a spokesperson for the family. They might be, and they might be around. What we're finding all the time now is people are retiring right and left, and people that created the trust are gone. They're retired and you can't find them. But that has nothing to do with the validity of trust. You read the trust and do what it says and follow California law.
Okay. Do you have to file the portable will with the court when trustees die?
Okay, you have to file the will with the court when a person who made the will died within 30 days of the date of death. And it's not the trustee that does that. It's anybody who has the will has that responsibility. It doesn't have to be the executor or anybody else who has it. That's the law says you're supposed to do that. You file it with the court, you bring in two versions and you get one stamp so you can prove you turned it into the court. And that does not start a probate. You're just meeting the requirement of the statute.
Is a trust within a trust recommended for unmarried couples?
Frequently, a trust within a trust, yes. It very well might be. Well, for unmarried couple, we do it more for people who have children from previous marriages. For unmarried couples, that they can have different distribution plans, and sometimes you want to have the assets of one of the partners to have those assets irrevocable until the surviving partner dies. And the surviving partner might have access to the funds after they go through all their own assets for health, maintenance, education, and support. But it's on a case-by-case basis. And if there's really different beneficiaries between each spouse, it oftentimes might be better to have some trust.
Okay. Can you give an example of a good time to create a testamentary trust?
I saw one where a gal had a young son and no relatives around at all. and she wanted to make sure that her son had proper supervision over the funds. She had a big apartment building. So she created a testamentary trust specifically for the supervision of the court. And I've seen other cases where the parents knew there was going to be litigation back and forth. It was absolutely, they knew litigation was coming. So they just said, we're going to put it in probate court already, and then you guys can duke it out at that point.
Okay. How many times can a settlor amend his trust before having to do a restatement?
There's not a number, but pretty soon you get to ridiculous. We've had them where you have to go through all these different documents to find out which one is, where is it now? It's just so confusing. I wouldn't want to do more than 2 or 3 amendments. And then I would want to completely amend it, revoke the prior wording, and restate the entire trust using the exact same name of the original trust.
Okay. Got quite a few. When the first spouse dies, can the second spouse change the beneficiaries after death of first?
It depends on what the trust says. There's a trust that we call the I Love You Trust, that husband and wife, the trust is revocable and changeable. And after the death of one spouse, it is still revocable and changeable. And
Okay.
the other way to do it is to say that half the assets, or when one spouse dies, none of the trust is revocable. And that way the beneficiaries cannot be changed. And we have more problems with blended families. People have marriages, kids from previous marriages.
Okay. In a simple probate avoidance trust with only asset is home and $200K cash, can the trust state that the home will be held for future family members in perpetuity?
You don't want to do it that way. Yes, well, not in perpetuity. You got the life and being plus 21 years. But what you want to do in that case, because of Proposition 19, you want to have the house go into the name of a child or children who can claim the property tax exclusion, so that the property tax doesn't go through the roof as if a new owner came in. And if you left it in a irrevocable trust long-term, you would get reassessed. And we've seen cases where they get reassessed $10,000 more a year in property tax. So you can do some of what you're talking about. I don't recommend it.
Okay. A married couple are vested as joint tenants. Do they need to deed to CP or CPWROS, then deed into the trust?
Okay, this has to do with changing character of property between separate and community before going into a trust. And frequently what we do when we have spouses where they've got joint tenancy is we will create a middle deed that says from joint tenants to husband and wife, community property with right of survivorship. And then from that deed, we will grant it to the trust. It's not required, it's recommended.
Okay. Do bank accounts need to be retitled in the trust name?
Yes. So do stockbroker accounts.
Okay, here's a long one. What shall a successor trustee do when the trust no longer has property or assets in the trust, yet there was an outside party who did borrow money from the decedent when he or she was alive and during the trustor's life sued the party in civil court? which the party has avoided attending court. Now, since the trustor had passed away, the successor has to continue the civil case on behalf of the estate of the decedent. There are
Okay,
no assets in the trust.
okay. There's two statements going on. There's no assets in the trust, but that's not true because you're telling me that there's a loan outstanding. And when there's a loan outstanding, the trustee is supposed to pursue and collect that asset.
Mm.
So, but there's some judgment involved here. If you're going to end up, there's no assets to continue litigation. The beneficiaries might sign off to say, we're not going to sue you, trustee, just drop the case because we're not kicking in extra money into an insolvent trust. But from a fiduciary duty standpoint, the trustee is supposed to go after and collect assets.
Okay. So this is about funding the trust. Is it better to transfer property from one spouse to both spouses and then to their trust? Would we have the same result if the property is transferred from one spouse to the trust?
Okay. The deciding point in that question is the property all that was acquired during marriage? Because for community property, it doesn't matter whose name the property's in, if the property was acquired during marriage in California. And the divorce attorneys will tell you that's the way it works. So it doesn't matter if it's acquired during marriage, it is community property, no matter whose name's on it. And it doesn't matter when you put it in a trust from that situation. It does not change from being community property.
Okay. Protection, you mentioned protection from Medicare. Is this called the AMPT or is the standard trust good?
Any trust is good. There's no special type of trust to avoid a Medi-Cal chargeback. The statute says if there's a trust, there's no Medi-Cal chargeback. If it's a will or intestate, the state has the right and the pressure from the federal government to do a chargeback and take the assets.
Okay, what happens to your home if you have a reverse mortgage? Can a lien be put on your home even if in a trust?
Reverse mortgages are one of the most horrible things in my view for estate planning, because what they guarantee is the beneficiaries are getting hardly anything. Because when you leave a home and you go to a nursing care facility, the loan can be called and due right now, and it must be paid off within 6 months. And when you die, the loan is due now, all of it. And so you create burdens for your beneficiaries. If a beneficiary wants to keep it in the family, the beneficiary has to put out their own credit statement, go and get a new loan, have the thing paid off before 6 months. I just frown on the reverse mortgages.
Is assignment of property to trust recorded?
You can record any document that's been notarized, so you can do that. It's not required. We usually do not do that.
And in California, is the Medi-Cal chargeback 3 years?
Which you're confusing two different things. That's assets to qualify for Medicare on the 3 years, but the chargeback goes as far back as Medi-Cal was paying payments. If it's been 10 years, they have 10 years at $7,000 a month to collect on.
Okay, we got about 10 more minutes here. Can we put only the name of the trust on the grant deed? For example, the grantee Gold Sword Revocable Trust, or does it have to state the grantee as Jane Doe as the trustee of the Gold Sword Trust dated 7/28/22?
Okay, you cannot in California, based on case law, only list the name of the trust. A trust cannot own property according to the court. you have to name, you put the property in the name of a trustee, Joe Trustee, as trustee of the Gold Bond Trust. And it must go that way or it's not validly titled in the name of the trust.
What happens when a person that is married and lives in community state property inherits an asset, real property? Do they get a 50% interest of the inheritance?
Based on community property law, community property is all property acquired during marriage, except for property you owned before marriage, and except for property that one of the spouses received from inheritance. So it stays as separate property to the inheritor. And we recommend keeping that money separate, not commingling it with any other of the family funds.
Okay, creditors can ask for the revocation of the revocable trust select from the individuals who sign up the revocable trust. Can creditors ask for the revocation of the revocable trust to collect?
I'm not sure where we are in that. It's a revocable trust. To find out it's already revoked, creditors will usually seek collection from the person who signed loan documents. So if you signed up as part of the trust, they might be able to sue the trust and the individual. I'm not sure that I understand the question.
Yeah. Would you recommend that us as LDA stay away from drafting special needs trusts?
I don't have an opinion on that because I don't know the qualification of each individual person. If they have studied up on it, they know how to do it, they know the requirements. I'm not going to render an opinion on that.
Okay, we have a few more. For separate property in the trust, what if the property was acquired before marriage?
If property was acquired before marriage, it is separate property. You put it in the trust, it does not change the character. It stays separate property. And then if you decide to revoke the trust, it comes back out as separate.
Okay. And can you expand a little bit more on joint tenancy property in a trust? If the property is sold before death of the surviving spouse versus after death?
Okay. When you have joint tenancy property and you put it in the trust, it's no longer joint tenancy. It's gone. The only problem is if you die when it's in joint tenancy, that's where the problems are.
Okay. Is a revocable trust protected from creditors?
A revocable trust has no creditor protection at all.
Okay. And the last question we have here, what's the time frame before passing away that Medi-Cal or Medicare can do a chargeback on your home? Is it 5 years?
If you're involved in Medi-Cal and you have no trust, I don't think there's any requirement that 5 years stops. I mean, if you've had Medi-Cal for 10 years at $7,000 a month, I don't think there's going to be a limitation. They can charge back everything, except if you have the house in a trust.
Okay. Rex, that is it. Normal questions.
Okay. Well, it's been a pleasure providing this information to you, and we'll meet again. Thanks for attending. Bye now.
Thank you. Bye-bye.